India Legal presents Courts Roundup.
Hello, I'm Hisha and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. And before we begin, here's the headlines. In Hathras case, Uttar Pradesh government files affidavit in the apex court, says adequate forces deployed for protection of victim's family. Fresh PIL demands case against officials under ST-SC Act. Delhi High Court seeks response from centre and Delhi government on registration of same-sex marriages, says laws are gender neutral. Try to interpret them for the rights of citizens. Delhi High Court Bar Association passes resolution condemning the allegation made by Andhra Pradesh Chief Minister Jaganmohan Reddy against Justice Ramana, says he is one of the most virtuous of the judges.
India Legal presents Courts Roundup.
In its affidavit before the Supreme Court in the Hathras case, the Uttar Pradesh government submitted that it has deployed adequate forces to ensure protection of the following members of the victim's family. The CJI S.A. Bobde-led bench had earlier directed the state government to place on record such details. Special Secretary Home Department Uttar Pradesh in his affidavit stated that the government of Uttar Pradesh is committed to provide complete security to the victim's family and the witnesses to ensure free and fair investigation. The state also requested the court to keep the petition pending, allowing the investigation by the CBI to be conducted under the supervision of the Honourable Court in a time-bound manner. It also sought a direction to CBI to submit fortnightly status report on the investigation to the state government. In order to ensure the security of victims' family witnesses threefold protection mechanism, the state explains in the affidavit. Government has also installed 8 CCTVs to ensure 24-hour surveillance observation of the premises. The entire security staff deployed at the village has been strictly instructed to ensure that there is no intrusion in the privacy of the victim's family, witnesses, and that they are free to move and meet the people they want. The plea raises the issue that the police authorities have not performed their duties and are shielding the accused. Additionally, the family of the victim is being victimized by upper caste person. A fresh PIL has been filed before the Supreme Court praying for registration of penal offences as well as offences under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act against the officials concerned. This PIL urges the court to direct registration of these offences against police officials, hospital staff and medical officers and other government officials who allegedly had a role to play in the destruction of evidence and shielding of the accused. This PIL says that the role played by the officials of the state, be it the police, district administration or the government hospital officials, is evident. It is pertinent for strict action to be taken against such erring officers to ensure that the faith of the people in the rule of law is not dissipated. The series of events as reported purportedly showed involvement and complicity of the state officials in destruction of evidence. The PIL alleges, adding that these officials appear to be shielding the accused person. After the incident of the alleged gang rape, the government of Uttar Pradesh hospital, where the victim was taken in Aligarh, did not collect requisite swabs and other samples despite visual indication of sexual offence having been committed against her. Forensic test was conducted delayedly, resulting in no semen sample being found, the PIL points out. Moreover, even before the investigation in the rape case has concluded, several high-ranking officials made public statements denying the commission of offence of rape. This, the petition says, indicates a clear nexus between the state police and the accused. The midnight cremation that followed after the victim succumbed to her injuries was another shocking step taken by the police officials and smacks of them being involved in the suppressing the crime rather than investigating it, the plea avers. The right to preemption is a very weak right and is capable of being defeated by all legitimate methods, including the claim of superior or equal rights, the Supreme Court has reiterated. Under this right, owner of an immovable property is entitled to repurchase and adjacent property which has been sold to someone else. The bench, comprising Justices Sanjay Kishan Kaul and Dinesh Maheshwari, observed that right of preemption is a right of substitution which cannot be exercised recurringly, but only once. The question considered in this appeal was whether the limitation shall commence from the first sale deed after coming into force of the Rajasthan Preemption Act 1966 or from any other subsequent sale on the basis of Article 97 of the Limitation Act in 1963. In this case, the plaintiff sought to enforce such right after 3 sale transactions had taken place in the past following the subject immovable property in the year 1945, 1946 and 1966. The historical perspective of the right of preemption shows that it owes its origination to the advent of the Mohammedan rule based on custom, which came to be accepted in various courts largely located in the north of India. The preemptor has been held by the judicial pronouncement to have 2 rights. Disagreeing with the High Court view, the bench observed that such a right is available once, whether to take it or leave it to a person having the right of preemption. And we are now joined by Advocate Shivam Sharma to give us more detail on this.
Yes, in this case, the question considered by the court is in this appeal was whether the limitation shall commence from the first stage deed after coming into force of the Rajasthan Preemption 1966 or from any other subsequent sale on the basis of Article 97 of the Limitation Act. The court, while referring to Bharat Eye Hospital and others versus the Kaustav Mandal case, the court said that the preemptor has been held by the judicial pronouncement to have 2 rights. First, the inherent or primary right, which is the right to the offer of a thing about to be sold, and the secondary or remedial right to follow the thing. Second, which is simply a right of substitution in place of the original vendor. Court also said that Section 9 of the Act operates as a bar on his exercising such right or a subsequent transaction relating to the same immobile properties. In this observation, the court has allowed the appeal. Yes.
Thank you, Shivam, for the update. The Delhi High Court Bar Association has passed a resolution condemning the allegation made by Chief Minister of Andhra Pradesh Y.S. Jaganmohan Reddy against Supreme Court Judge Justice N.V. Ramana and other judges of the Andhra Pradesh High Court. DHCBA said the Delhi High Court Bar Association unequivocally, categorically and in strongest possible terms condemned the allegation cast upon Honorable Justice N.V. Ramana. A resolution to this effect was passed in view of the media report that Reddy addressed a letter to Chief Justice of India levelling serious allegation against Justice Ramana. In this letter addressed to CJI Bobde, CM Reddy had alleged that former Andhra Pradesh Chief Minister N. Chandrababu Naidu was using the High Court to destabilize and topple the democratically elected state government. The letter alleged that since the new government undertook an inquiry into the action of Naidu during his 2014-2019 regime, it was now clear that a sitting Supreme Court judge started influencing the course of administration of justice in the state through the Chief Justice. DHCBA has added that Justice Ramana, who is next in line to become the CJI, has been one of the most virtuous judges with the highest level of integrity. Thus, DHCBA has condemned the blatant attempt to shake the confidence of public in judicial institution. The Delhi High Court issued notice to the centre and Delhi government on two separate petitions seeking registration of same-sex marriages under the provision of Special Marriage Act 1954. One of the pleas seeks direction that it be declared that the Special Marriage Act 1954 applies to all regardless of gender and sexual orientation. The matter will be heard next on January 8.
The Delhi High Court has sought the government's response on two separate petitions filed by same-sex couple related to registration of marriage under the provisions of Special Marriage Act and Foreign Marriage Act. The court said that age-old inhibitions have to be shed after Advocate Rajkumar Yadav, one of the counsels for the centre, submitted that this situation has not arisen in the 5,000th year of Sanatan Dharma. The couple's petitions argued that the non-recognition of marriage between LGBTQ persons violated the fundamental right of liberty, equality, life and freedom of expression guaranteed to them by the Supreme Court. We would be like to recognize as full human being, argued senior advocate Menka Guruswamy on behalf of two same-sex couples who have petitioned the Delhi High Court for the legal recognition of same-sex marriage. The petitioners have filed writ petition urging that the Special Marriage Act and the Foreign Marriage Act be interpreted to also apply to the marriages of same-sex couples. The Delhi High Court bench of Justice R.S. Law and Asha Menon issued notice in the matter and fixed the cases for further hearing on 8th January 2021. The central government standing counsel, Advocate Kirtiman Singh, agreed that the matter cannot be treated as adversarial. The matter involved two petitions filed by two same-sex couples. One couple has assailed the prevailing interpretation of the Special Marriage Act. Through senior advocate Guruswamy, they told the court today that when they approached the concerned subdivisional magistrate to apply for marriage, they were refused even entry into the building. Another same-sex couple, two men who had been married by the highest-ranking Indian judge in New York, were denied the registration of their marriage under the Foreign Marriages Act by the Indian consulate in New York. Taking the court through correspondence between the couple and the consulate officials, Guruswamy told the court that the consulate had openly admitted to have denied the marriage registration on the ground of sexual orientation alone. The couple was told that the prevailing guidelines do not permit the registration of their marriage. Guruswamy asserted that the authorities' action clearly indicated that they were not aware of the Supreme Court's pronouncement in Puttuswamy's case and Navtej Singh Johar case, whereby the apex court had ruled against discrimination on the grounds of sexual orientation. The right to choose a partner of one's choice was also underscored in these rulings. By refusing to allow the petitioner to marry or register their marriage, their inherent rights to dignity and expectation of constitutional morality had been violated, she argued. Justice Law pointed out that the definition of marriage in Indian law has not been statutorily defined, which meant that authorities generally relied on its customary interpretation, he observed. Guruswamy also drew the court's attention to how special rights are given to married couple in terms of buying a house, availing life insurance policy, taking care of the family of one's partner, getting loan and having a bank account. In the later case, the Supreme Court had also observed that the purpose of marriage goes beyond mere procreation, she pointed out. In this backdrop, she argued that the petitioners simply want to be recognized as full citizens. Notice in the matter has been accepted by both the Union of India and the Government of Delhi today. The court directed them to file affidavits within 4 weeks and the rejoinders thereto may be filed within 4 weeks thereafter. The matter has been listed for hearing on 8th January. Notably, while responding to the earlier plea, the Solicitor General Tushar Mehta had told the Delhi High Court, "Our legal system and values do not recognize marriage, which is sacramental, between same-sex couples. Bureau Report.
A Delhi court will pronounce order on sentence against former Union Minister of State Dilip Ray and others in connection with the 1999 Jharkhand coal scam on 26th of October. Bharat Parashar, a special CBI judge, has directed the physical presence of all convicted persons on the said date. Take all precautions of COVID-19, Judge Prakashar said as he asked all counsel to ensure the presence of their client. While the counsel for the convict has sought leniency from court on account of the age and medical conditions, state pressed for maximum punishment. Earlier this month, the court had convicted Ray and others for the offence of criminal conspiracy and other offences in connection with the coal scam. The case pertains to irregularities in acquisition of a Jharkhand coal block in 1999 when Ray was Minister of State for Coal in the Atal Bihari Vajpayee government. Apart from Ray, the court also convicted two former senior officials of the Ministry of Coal, Pradeep Kumar Banerjee and Nityan Nand Gautam, as well as Director of Castron Technology Limited, Mahendra Kumar Agarwala. The Karnataka High Court has refused to quash a criminal case registered against former Chief Minister H.D. Kumarswamy, alleging that he denotified two different plots of land acquired by the Bangalore Development Authority during his tenure as Chief Minister between June 2006 and October 2007 for pecuniary gains, and Justice John Michael Kunha, while dismissing the petition, said there is sufficient material to proceed against the petitioner for the alleged offences. In the absence of any material to show that the action initiated against the petitioner is an abuse of process of court and has resulted in a failure of justice, there is no ground to quash the impugned proceeding as sought for in the petition. Complainant M.S. Mahadeva Swamy had filed a private complaint before the Additional City Civil and Special Judge for Prevention of Corruption Act, seeking prosecution of the petitioner and 18 others. The special judge referred the complaint for investigation under Section 156(3) of CRPC. After investigation of a B report was submitted by Lokayuta Police, it was also claimed that the special court had utterly failed to apply its mind to the fact of the case and has passed the impugned order without application of mind and in violation of the statutory rules. Finally, it was submitted that proceedings initiated against the petitioner are malified and ulteriorly motivated. The complainant being a political opponent of the petitioner, the allegation made in the complaint are actuated by the malice and are calculated by the tarnish the image of the petitioner. The Punjab and Haryana court has sought an explanation from a district judge for supposedly showing undue favour to the plaintiff in a suit. The district judge has been ordered to file a detailed explanation for the supposed favours within 30 days. During the course of hearing, Justice Sangwan took note that case proceedings were also being delayed on account the time taken to exchange case record between the trial court and district court. The High Court has now directed the transfer of the case to an additional district judge. The case arose out of the suit filed by SEL Manufacturing Company Limited and Neeraj Saluja, praying for the restructuring of a loan availed for SBI. Additionally, they also filed an interlocutory application seeking to restrain SBI from taking coercive steps against them for the alleged non-payment of the loan. While the civil court rejected this prayer, the plaintiff approached the Nawan Shahar district judge, who granted the plaintiff relief in ad interim proceeding. When the bank appeared to argue the matter, the plaintiff failed to appear. As a result of the plaintiff's non-appearance, the suit was dismissed for non-prosecution. Despite this, the district judge on appeal extended the temporary injunction. The bank challenged the district judge's order in a petition filed under Article 227 of the Constitution before the High Court. The High Court found that the bank appeal deserved to be allowed since there was total non-application of judicial mind on the part of the appellate court district judge in continuing the injunction order even after the original suit was dismissed for non-prosecution. The Bombay High Court has accepted the unconditional apology tendered by Payal Ghosh in the defamation suit filed against her and Kamal R. Khan and channeled by fellow actress Richa Chadha. Ghosh submitted the apology along with a statement agreeing to withdraw all disputed posts uploaded by her against Chadha from all her social media handles. Appearing for Chadha, her lawyer informed the court that these terms have been agreed and signed by both parties. In view of the term, the suit does not lie against Ghosh anymore, and Ghosh lawyer urged the court to direct both Kamal R. Khan and channel to withdraw the existing disputed content. The court also asked Advocate Nikhil Mishra, appearing for channel, if he had any instruction from the channel. Mishra informed the court that the channel is willing to submit to the injunction order. Advocate Manoj Gadkari, appearing for Kamal R. Khan, was asked by the court whether or not he would withdraw the content. Gadkari informed the court that his client wishes to make a statement that he will withdraw the disputed content, and when the court asked him to file an affidavit to that effect, Gadkari said he needed more time. He further submitted that Khan would not upload any statement or share any content disputed by Chadha in the suit. The court recorded Gadkari's statement and granted him 4 weeks' time to file an affidavit in reply. The Jharkhand High Court recently came down strongly on the state police for its shorty the investigation into the murder of a woman and her 3 children by burning them alive. It was also alleged that the police was sabotaging the investigation and aiding the accused, who were threatening the family of the deceased. Taking a strong exception to how the investigation was stated to have proceeded, Justice Anand Sen said there is no room for any laches or laxity while investigating a heinous crime against women and children, nor any laches can be tolerated. The margin of error is 0. Noting that the allegation was serious, the Justice Anand Sen called for the case diary to be produced in the court, and the case diaries maintained in the case revealed that the statement of doctors and nurses to whom she had confessed were not taken, despite it being averred in the FIR. In a further twist in events, the first diary was supplemented by a second, which recorded some findings by the supervisory authority. The authority stated that the woman had been discovered to have been in a relationship with another person, and that sparked the differences between the married couple. The matter was to have been referred to a panchayati, but unfortunate event occurred, he recorded. Taking all these instances into account, the DGP was asked for his view, and he submitted that the CID inquiry into the matter would be the best option. On this note, the court ordered that the investigation be transferred to the CID and the investigating officer and the supervisory authority be relieved from handling the case and investigating other crimes. And that's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.